Good evening, everyone. It's 5 p.m. on May the 5th, 2022, and this is a special council meeting of the City of Bel Air Beach. The purpose of this meeting is to interview applicants for RFP 22-01 for legal services, city attorney, and make selection by ballot. First off, do I have I'm sorry, before we get started, I'd like to go ahead and do the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Patty, would you please call the roll?
Councilmember Frank Banker,
Present.
Councilmember Leslie Notero. Here. Councilmember Lloyd Roberts,
Here.
Councilmember Jody Shirley. Here. Councilmember Mike Sable,
Here.
Vice Mayor Glenn Gunn,
Here.
Mayor Dave Gaddis,
Present.
and City Manager Lynn Reeves.
Here. Thank you. As mentioned before, we only have one item on the agenda for this meeting, and that's to interview applicants for RFP 22-01 legal services, role of city attorney, and make selection by ballot. First off, do I have a motion?
Motion to move.
Do I have a second?
Second.
All right, so what we're going to do is interview these two candidates. We're going to start with Trask Danio LLP, and if you'd like, please step up to the podium, introduce yourself, and let's hear about your services.
Thank you very much, members of the council. My name is Randy Mora. I'm a partner at the Trask Danio Law Firm. I'm joined this evening by my partner, Tom Trask, our real estate associate, Megan Hamasevich, and our other litigation associate, municipal associate, Jeremy Simon. My partner, Jay Danio, sends his regrets of not being able to attend. It is his birthday, and I think his other constituent base was very concerned with his presence at home. And also my partner, Eric Augello, had a family commitment some months ago that had been scheduled. But as I said, my name is Randy Mora. I'm a partner at the Trask Danio Law Firm. Our firm specializes almost exclusively in the representation of local governments. I've been with the firm for a little more than 8 years now. I'm a partner. I'm board certified in city, county, and local government. I've been the town attorney for the town of Kenneth City since August of 2014, and the city attorney in Indian Rocks Beach for roughly 7 years, just a little less than I've been in Kenneth City. You recently, as you well know, went to the market seeking attorney services, and we responded, and that brings us here this evening. And I say it that way because I want to emphasize what it is you said you were looking for. You said you were looking for an attorney who can provide you exceptional communication, exceptional understanding of the council manager form of government, in innovative and creative solutions, and the capacity to work with a variety of diverse groups while maintaining civility, order, and independent legal advice. I'd submit to you, I think I'm unequivocally the best candidate for that based on those qualifications. I have a demonstrated, I have a demonstrated record and history serving local governments in this community. Going further back than that, I am, as I joke, a tremendous dork. I met my wife doing YMCA Youth in Government some 20 years ago almost. This is my life's passion. I feel very passionately about the service to local government and the protection and preservation of the public trust. Our system is founded on people like you making those sacrifices. And I want to begin by thanking you for the time you spend here. Even if I'm not selected, it's important to know that this is a critical part of the process of our governance. I believe in this so passionately that in addition to serving as the town attorney in Kenneth City and also in Indian Rocks Beach, I also travel the state working with the Florida League of Cities and Florida Municipal Insurance Trust to educate elected officials across the state. I was in South Florida last week speaking on ransomware and local government, technological and innovative issues. I've been working with the Institute of Elected Municipal Officials. I regularly speak on sunshine law, public records, ethics, and their intersection with technology. I've also been, I've traveled as far as Daytona to provide education on parliamentary procedure and how a body can become a more cohesive and effective body in doing its business. And based on that, have been asked by other communities to do the same. In addition to those educational services, my partners and I are also panel counsel with the Florida Municipal Insurance Trust, the Florida League of Cities Insurance Agency. And through that, we've had the pleasure of representing this community and some of its officials historically. We represent communities as far south as Bonita Springs in that, and as far now north as Yankeetown, towards the Panhandle, or at least that pivot. And so through that, I've gained a comprehensive understanding of the needs of local governments across the state, not just in this community, but most especially in Pinellas County. With that travel experience and variety of experiences, I've also come to understand what the emerging issues are to assist local governments in getting ahead of problems and being proactive in their solutions and not purely reactive. I do not consider myself in your community, 8th commissioner. I have no interest in being a policymaker. I have an interest in helping you shape policy, helping you to make effective policy, offering you guidance on what may be lawful, what is prudent, and ultimately allowing you to make that decision, right or wrong. I am a husband and a parent. I give advice all the time that's ignored. That's part of the job. But we make sure you have the advice, that you go in with informed knowledge through your process. And that's really where I think I am the best fit based on that flexibility. I've dealt with issues of first impression in the law and local municipal government, even in my first 10 years of a career, that I know peers who've been doing this 30 and 40 years and have never confronted. And I think I've handled those situations with poise, trying to understand the interests of the shareholders, the council members or commissioners at the time, and recognizing while their interests may not align, there may be a path forward to find that compromise that works for a community. In addition to that, I am not the only attorney you would be hiring if you hired me. You would be hiring our firm. We believe in a firm-oriented practice. It's why I'm joined by my colleagues this evening. You get the depth of that bench, if you will. We have collectively, just among the partnership, I think we're now over nearly 70 years of collective experience over the partnership. That is, and each with our own specializations. My partner, Tom Trask, has extensive experience in code enforcement, liens, collections, and things of that nature. My colleague Jay Daigneault has a tremendous experience in 1983 cases and the litigation needs of a community, especially appellate needs. My colleague Erica Augello has extensive experience, especially for an attorney, on issues of the Florida Building Code and the like. As I've said, I've established some of what my specializations are, and that's not to say those are the only things we know about. Those are just some of the issues that we have depth in. We also have a real estate practice, and we keep that within our practice, not because it necessarily serves public entities on a day-to-day basis, but there will come needs where we will have to vacate an easement, look at a right of way, and it's helpful to have that kind of depth in your bench and those kinds of resources and bring them to bear for the communities we represent. I love the sound of my own voice. I could keep going. I'm an attorney, but I would rather make sure that you get the information from me that you came here for. You have my resume and my statements and how we and our ethos on how we intend to deliver services. And so if you have questions about that, I'd rather spend the balance of my time addressing your inquiries.
Thank you very much. The way that I'm going to handle this is I'm going to call on each one of you. And so what I'm going to do is start with Frank Bankert, move this direction, and as soon as it gets to me, then we'll go down to Mike Zabel and come back this way, then the vice mayor, and then myself. And we'll just keep repeating that cycle until we're completely exhausted. You okay with that?
I'm committed to it. Let's
Okay,
do it. Let's
great,
exhaust some
great.
people.
All right, Mr. Bankert, do you have any questions?
Just one. You're proposing a $3,000 retainer fee. And looking at that, what it covers, what doesn't it cover, I guess?
It's an excellent question. The question for the benefit of everybody was, we're proposing a $3,000 retainer. So what is not covered by that retainer? That retainer is considerably comprehensive, and it's intended to be. We represent presently a dozen communities between Manatee and Pinellas County, and we've, I think, fine-tuned that process. The retainer is intended to capture everything except functionally litigation services, It's though the topics are enumerated in the response, it's really where things get to be either a special project. Let's say we're going to be doing, we're doing something unorthodox, or we are going to craft the first short-term rental ordinance that does X in the state. And we're going to be going into new issues of the law that's going to require extensive research. I may come to you or your manager at the time and say, help me, or not help me, but I believe this is going to require special attention. And usually when I do that, I'm talking about something that's going to take about 15 hours or more outside of the retainer. And then at that point I say, hey, we've got a special project on our hands. Other than special projects, it's litigation. Code enforcement, we consider to be litigation. If we prosecute those for you, I know you're represented by PCSO and PCSO handles that, but when it gets to whether you use a magistrate or a courthouse and you need somebody there to preserve either the process or actually prosecute it, we do that outside of the retainer because that's hard to control it's going to always be this way. But generally speaking, virtually all of my attendance at your meetings, unless again, we're doing special meetings and I'll give you an example. I have a retainer in the town of Kenneth City. Last year, their manager, clerk, and 2 people in town hall all resigned within about a month of each other. And I was the last person standing, if you will, the last charter official there. And I facilitated that transition while being an advisor and never occupying that role. But I told them this transition, this is special. This is different from business as usual. And I will make the distinction between I'm just interpreting your ordinances or writing a new ordinance. That's still retainer, even if we're in this weird transition. Now, if I'm doing this other thing, that's outside the retainer. It was a special project. So it'd really be those like litigation and special projects and things out of the ordinary. I want to also touch on the fact, and I meant to state this, I know that you're in transition as your esteemed manager who I've had the opportunity of working with in the past is retiring. Because of that circumstance, I'm very familiar with the process of helping a council and a manager navigate a transition. And I'm also prepared to facilitate in as much as the role of the attorney is relevant to that process.
Thank you.
Leslie Nataro,
I have no questions.
Thank you.
Lloyd Roberts.
Yes, Randy. So currently, one of your occupations are the assistant town attorney for the town of Bel Air. So what is the role of the assistant town attorney is?
That was we recently became, our firm recently became legal counsel in Bel Air as recently as December of 2021. The way we structured that was with a principal attorney. My colleague Jay Daigneault is their city attorney. I'm the assistant city attorney. The way we've crafted that has been very specific to that community. It's if Jay's unavailable, I'm there. They have a second person they can call. I've covered meetings where there's been conflicts in terms of scheduling, not legal issues. Or said differently, hey, we have 2 special projects going on. Let's divide the labor to make sure the client's needs are met in a timely fashion rather than say Jay can only take the one thing at a time. We're deploying 2 attorneys on that issue, both of whom are recognized and familiar with the council or commission so that they're best poised to work with us and we're familiar faces for them. So it's really, there's nothing special to it except to say that I'm not the designated charter official they go to first. I'm the backup.
And just a quick follow-up to that then. So for the town of Kenneth City and Indian Rocks Beach, when do they meet? Do they meet monthly and you meet with them once a month? And what day of the month?
Yes, it's my understanding your meetings are presently on Mondays. The City of Indian Rocks Beach meets on Tuesdays. It's ordinarily the second Tuesday of the month.
Okay.
They meet once a month. They do also have subordinate boards that I or some of my colleagues like Jeremy attend for them, but those don't meet on Mondays. Town of Kenneth City ordinarily meets on the second Wednesday of the month, occasionally on the 4th Wednesday for a workshop or something of the sort. I'll tell you that their manager recently provided notice and they're meeting a little more frequently than they might ordinarily do. But that is,
Okay.
That's the meeting schedule.
Perfect. Thank you.
Mike Zabel.
Yeah, if you drove to the meeting tonight, passing over Causeway, you looked at it, a large expanse of water, probably a few sailboats out here. Can you walk me through the process that you would follow in basically evicting these type of boats that have been moored for months?
I appreciate the question. I'll tell you that's a nuanced area of the law. There have been some more recent changes on what authority cities have to go through that process. I don't feel comfortable giving you the step-by-step legal process just because I haven't had occasion to revisit that in the last 4 years as an actual process. We had that inquiry come up in Indian Rocks Beach, and I did research it for them, but the boat happened to be X amount of feet beyond their coastal boundaries such that, that the person knew where they were mooring. But that is, I will tell you, that is a problem that is up and down coastal Florida. That is an issue in our coastal communities, but we have navigated that in our office more recently in some of our other communities, working with PCSO, because part of it is what is the community willing to do, but then also what is your enforcement body willing to do, and do our legal positions on those issues align? I would tell you that my first step would be to collaborate with your manager and PCSO to say what has been done historically, what enforcement mechanisms have succeeded, failed, and reviewing the current state of the law to determine if we can, as your RFP materials say, find a newer, innovative solution with a fresh perspective, or if we just need to continue a process that may have been abandoned or sidelined because of other priorities at the time.
Jody Shirley.
So most of my questions have been answered, but I do have one specific to your firm is representing Bel Air Beach and several council members and citizens through the League of Cities on an active lawsuit. Does that cause any conflicts?
In my estimation, no, it does not. That is not unprecedented. We represent other communities like the city of Tarpon Springs, where their officials or the city itself has been sued, and we principally serve as their city attorney and the litigation counsel. That is a separate arrangement through the insurance trust, and those would be separate and distinct. And where it presents an issue, we would determine that. We have, where there is conflict, we get conflict counsel. We are not shy about that, but that is our determination to make and then advise you on. But as far as the current engagement, I'm not inclined to comment on the substantive elements of the active litigation. I'll let the documents in the court record speak for themselves. But I would just say that I don't foresee that being any impediment to our ability to provide you legal services in a prompt and responsible manner.
Okay, that was it for me.
Glenn Gunn.
Hi, Randy. Good to see you, and
Likewise.
thank you for your time. I actually have 3 questions for you. The first one is, have you read through the existing city attorney contract?
With Mr. Salzman or Mr. Riley's previous contract?
The previous contract?
I have not reviewed Mr. Riley's contract or Mr. Salzman's contract. We would propose, we have one that we tend to use, and I would stand on the merits of our agreement with you. And if there's things if we are selected and you wish to negotiate with us and you find there's elements in your current attorney's contract that you would like seen in ours, and we can resolve that, then we will. I know that because our firm did apply back in, I believe it was 2019 when you last went out to bid. I do know that Mr. Riley had a habit or a billing practice of billing in a particular increment, different than the general industry standard of 6 minutes. We do the 0.1, 0.2, and 6 minute increments to divide an hour. So that's one thing that I know is distinct from how Mr. Riley approached billing. But other than that, I can't independently comment on his contract or the town's previous contracts. If there's something you wish for me to address, I'm happy to do so.
Okay, so, I'm familiar with your work with the IEMO and Florida League of Cities, and come to know your expertise a little bit. One of the things that we've tried to change in our recent contracts is to try to engender more of a consensus direction to the city attorney. In other words, direction to the city attorney comes from only one of 2 places, either the city manager or the council in itself. And so while I understand that while individuals may call you for information or clarification on legal issues, my question is do you understand that when it comes to taking direction for assisting us with legal work or resolutions or ordinances, drafts, that sort of thing, that you take that direction from the city manager or council? Do you have any concerns or see any conflicts there?
I have no concerns. I would say if that's a concern of yours, that it's better addressed in your code or your rules of procedure as opposed to a contract. But I would tell you that to me, that's not a novel concept. And your council manager form of government under our Florida Bar ethical rules and otherwise, our client is a body, it's a collective. I work for the 7 of you, and there may be 3 of you that want something done and 4 of you who do not, and that may inform what work product ends up happening. And that happens all the time, but I work for all of you. If one of you comes to me with an idea and says, Randy, I would really like to explore, I'll pick something off the wall. We want to take our logo and make it an NFT for digital sale in the, Bitcoin metaverse or something like that. Please move forward. And then you say all those words and they sound like mumbo jumbo to your peers. And they say, why are we wasting time on this? I'm not going to keep going just because one of you is very passionate that this presents an economic opportunity for your organization with, new legal innovative solutions. I work for the body. And I will tell you that at times that's created tension, not tension, but an issue between me and my clients, and explaining to them, I'm not against your proposed solution. Just get your peers to tell me that that's what they want, and I'll do it. And so that is how that relationship should ordinarily work, is with all of you as the client, and trying to harmonize that where possible.
Okay, thank you for that explanation. And item last, and this really defers to your experience with the Florida League of Cities and the IEMO, is explain to me a little bit in your background and experience, what distinguishes an elected official from a citizen? Are there certain things that an elected official has to keep in mind in dealings with the public, or how he relates to the public, answers questions, or that sort of thing, vice just as a resident stepping up to the podium?
It was my understanding I only had 20 minutes. Your question, thank you. I think I have 3 hours now, so I appreciate that. Jokes aside, there are some very real distinctions. The moment you become, I joke in my presentations that the high point, the best day of your public service is the moment that those election results are read and finalized and you won. It's kind of downhill from there. I joke because you're here in service of the warm fuzzy feeling of trying to help the people around you and achieve the goals of making your community better. But in doing that, you're going to face criticism. You're going to face ridicule. That's part of the job. And that's a difference. I was having this conversation with a family member. There are things I have to tolerate sitting at the dais that I would not tolerate from a private individual in my life. I would cut that person out, so that's part of it. The other thing is, what separates them is the voters. The voters separate them. Your constituents picked you. In the case of the most recent election, each of you, by nearly a quarter of the populace, of the populace that voted, at least, picked you. You have a backing. You have in some cases, a mandate or a directive from your constituency base that you're acting upon. Individual residents don't have that same level of accountability. They get to be an individual resident the day after and before an election, and it doesn't change. That can change for you. That's a very real tangible difference. The other tangible differences are abounding. You become an agency under the public records law. You have public records duty that private officials don't. You have sunshine law obligations. You have ethical restrictions, criminal restrictions, all of these things that extend you. It fundamentally changes your life to become a public official. It's why anytime I speak before you, I thank you, because you agreed to fundamentally change things about your life overnight in service of the greater good. It's sort of an absurd notion to some. And so I think, yes, there are very real, very tangible differences, both in the law and as a matter of practicality, that change that. And then separately, I work for you. There will be times where your residents come to me as the city attorney and say, hey, I have a question. Now, if I'm sitting here at the days, they say, I have a question about tonight. I heard this. Is that what they're going to do? Last night at the meeting, somebody said, is there going to be public comment? We're in a workshop, and I explained to them the difference between a workshop and a meeting, and they don't have to legally do it. That doesn't mean as a matter of policy, the presiding officer won't do it. And I explain all that. But if a resident contacts me and says, Randy, I'd like us to research how to get unmoored boats out, that's not my client. I don't take that direction. That's another difference. I mean, they are, in my estimation, somewhat countless, but there are very tangible and real differences between the role of the resident and what you are still residents of this community. You don't cease to be residents, but you have elevated duties, responsibilities, liabilities by taking this mantle.
So the follow-up to that question is there an appropriateness to or difference between, as an elected official, giving an opinion as an elected official, vice saying, I'm taking off my elected official hat and I'm putting on my citizen's hat, and I'm going to speak as a citizen now from the dais? Is there?
I'm not sure I fully understand the contours of the question. I will tell you that the law recognizes immunities for what is said from the dais, so that there is not a chilling effect in our democratic process, so that you recognize from up here, I can say a lot more than I might even be able to say the moment I leave this room, even though I'm wearing the same hat. But those distinctions will have to be made. The wonderful lawyer answer to your question is it depends. I would have to take those circumstances as they come, because if you say, oh, I'm taking off my official's hat, but it's my opinion that all the elected officials should be given free things everywhere they go, and I'm going to be the agent of change in this community, that's not great. No, you can't do that. But you are not stripped of your ability to opine on the events in your community, and you can choose to say whether it's on the record or off the record, or as the vice mayor or as a resident. But you also have to recognize the public is going to choose to perceive it and process it and characterize it its own way, and you can't always control that.
Well put, thank you.
All right. Currently, we have a policy or an ordinance for signs that is not being enforced in this community. It has been found that it is unconstitutional. Could you briefly give me an overview of what you would do to correct that problem and give us an enforceable sign ordinance that it wouldn't be worth the time to challenge it?
Absolutely. And in as much as I can, I want to assure you that this is not a problem unique to your community. You guys are clearly in really great shape. I mean, FMIT was here 2 weeks ago, or in 2 meetings ago, commending you for being a leader in establishing best practices in risk management. You were commended for your financial practices. You guys are moving in a very positive direction. The fact that there are unresolved issues, there will always be more. Where that comes from is around 2015, the Supreme Court decided a case called Reed v. Gilbert out of the state of Arizona, where they functionally upended municipal regulation of signs by saying non-commercial speech has to be regulated, especially for temporary signage, has to be regulated in what they characterize as a content neutral manner, which is what we all know. You can't say it's a yay for this position, no for that position. But the practical effect of that is all temporary signage, whether it is come to the Boy Scouts meeting, Komen for the Cure 5K, vote Dave Gaddis mayor, have to be treated the same. Or come to this real estate open house. And trying to reconcile those disparate, where we have ordinarily said, well, real estate signs are regulated this way, and political signs are regulated this way, and temporary events are regulated this other way. We have to now find a uniform system for regulating all of those. And that is the challenge that you're facing. We have personnel in our city who have drafted codes. In fact, one of my colleagues who couldn't join us tonight, Robert Eschenfelder, drafted a sign code for the city of Lake Hamilton. We are not engaged there otherwise. He was specifically retained because we have drafted sign codes. Specifically, he has drafted sign codes for other cities like the city of Dunedin and Oldsmar and other cities. And so we would bring to bear that resource, that template, bring it to you, say, here's what we ordinarily do. Let's make sure it fits the needs of your community. Go through the appropriate channels, likely your land planning agency or planning and zoning board, then an ordinance that you would see on first and second reading. And that's how we would go through that. But the first steps of that, and I'm presently doing that in Indian Rocks Beach right now, for various reasons. In a lot of communities, it was harder to move forward. And then just as many communities got traction and an understanding of how that jurisprudence had changed things, then life happened in 2020 and it sort of derailed people's legislative priorities. But be that as it may, we're prepared to address that issue. And I would just wish to offer you some comfort that a lot of communities are still playing catch up. There was a decision issued just in the last 2 months by the Supreme Court on that line of jurisprudence and what's permissible in terms of temporary signage and what you can and can't do. And so we continue to monitor that on a real-time basis.
Thank you. Back to Frank Bankard.
Real quick question. How many pages is the sign ordinance that you drafted in the other city?
It varies city to city, but I will tell you, because you're talking about changing your code in response to a Supreme Court decision, they tend to be lengthy in the first anywhere from 5 to 10 pages with whereas clauses and findings. That's not ordinarily how we draft things, but we recognize that area of the law is susceptible to legal challenge. And we try to provide you all of the material you need to establish that you considered, that you were aware of, and that you harmonized in making that adoption. You tried to harmonize it with all those legal pronouncements. So the ordinance can be, and again, it's community by community. Some strip out a lot of stuff, but they're anywhere from I want to say 20 to 40 pages, but that can be stripped down with an understanding of the risks you take in trying to just make it quick and easy.
Because our ordinance right now, I think, is about 6 pages, and it went from, and Fred Riley did an excellent job. I'm not putting any fault to him, but it grew to about 26 pages, and I don't think most of any of it, our council could stomach that big of an ordinance.
We work at your pleasure, but we will give you advice on what is legally, what Attorney Riley did is commensurate with what has been done across community in the state of Florida. For a while after that opinion, there were only 2 law firms in the state who were drafting templates. Most wouldn't touch it with a 10-foot pole because of the risks. And out of that has grown the templates, plural, that other communities have used, but very rarely, based on how nuanced that case law is and all the things that you're trying to address. And now we have the added specter of recent case law like Senate Bill 620 that may create potential claims for businesses if they feel that they've suffered business damages by virtue of a legislative change, that you're trying to harmonize all of those and mitigate all those interests. And it's very hard to reconcile those disparate interests and do so in 5 to 7 pages.
Thank you.
Leslie Nataro.
No questions.
All right, Lloyd Roberts.
No further questions.
Mike Zabel.
Yeah, specifically, have you and your firm dealt with negotiation, mediation, fact-finding, or arbitration? And specifically, have you ever done this between neighboring municipalities?
Short answer, yes. There were a few things in there. We regularly deal with mediation. Mediation is almost an immediate element of litigation, no matter who the parties involved are, whether they be private litigants. We are presently representing a community in a county south of here who is going through what we would call an intergovernmental dispute and navigating that. There's a very specific statutory process and a series of meetings you have to have with specific attendees when you are mediating to avoid litigation with another governmental entity, whether that be a community development district, a municipality, or the like. So yes, we have experience on it. I've personally researched it. My colleague Jay Daigneault is handling that particular suit that I've referenced, and they went through all those steps, and still, unfortunately, based on the parties' positions, it involved garbage trucks on roadways and who's responsible for what repairs and damages. But that is ongoing litigation. But yes, we are familiar with that.
Jody Shirley.
I have no more questions.
Glenn Gunn.
One last question. How do you factor in risk management into your recommendations or advice to the city council? In other words, if we're dealing with an issue and there is a 20% chance that this will end up in litigation, do you factor that in your recommendation and advice of maybe, this is my expert opinion, there's a 20% chance, and because it's so remote, I would recommend that you move forward with it, understanding that there is a risk there, or do you just say, nope, there's a chance of litigation, I recommend we not deal with it?
I've never once advised a client that the simple prospect of litigation is the reason enough, unless they are just actively doing something that is clearly unlawful. We're going to make sure that nobody can ever speak at a meeting again. Okay, you can't do that. I'm not going to go down that route. But the prospect of, I tell my public officials all the time, there's 3 core rules to doing what you do. 1, don't mess up. 2, you're human, you're going to mess up. Don't hide it or avoid it. And 3, critical to your question, just because someone says you messed up doesn't mean you did. The reality is that somebody can sue for any reason, and that doesn't necessarily make that suit meritorious. I will tell you how likely I think that is based on our knowledge of the litigation landscape. And I've done that in, for example, Indian Rocks Beach, as we worked through their short-term rental ordinance, I advised them, hey, there were a few council members that said, I would like to see a restriction that looks like X. I said, well, we can do that. There's nothing that says we clearly can't. I will tell you, we've represented another community that has faced $25 million in litigation claims based on that restriction. And we're actively litigating it. I don't know how the court will resolve it. And I don't know, that may get appealed, and I don't know what an appellate court will do. If you have the insurance coverage, stomach for litigation, you can take that risk, but you need to know it exists. I try to shy away from, I know people want objective numbers. Is it 20%, 40%? I try to shy away from that because that's just so hard to gauge, to really tell you what the what the viability of litigation is. And sometimes that can vary by communities. Communities with, for lack of a better term, more resources, or residents that have more resources and more time tend to be more litigious because those residents can afford to engage in that process. And so it's hard to definitively predict when you'll face that. But yes, I try to make sure you're aware. My goal is not to make a decision. My goal is to give you the information you need to make an informed decision. And to make sure that a year later, 2 years later, you don't say, well, Randy never told me. Had I known, I wouldn't have. You may disavow having been told. That's a whole different thing. But I will make sure, it is my goal, I'm human and myself capable of error, but it is always my goal to make sure that you have as much information as practical to make an informed decision from the legal side. There may be administrative concerns, and I'll turn to your manager, whomever is in that seat going forward, and work with them. In my ethos, I will tell you from a work product standpoint, when we're talking about new policy, I consider your manager, clerk, and attorney sort of like your team Avengers. They are going to need to swoop in and work together to get you something, because each of us deals with a different facet of how that's going to work out for you. And we need to make sure that's harmonized. I do no good if I help you draft a policy that your manager is either unwilling or incapable of enforcing. And so we try to harmonize those things early in the process, rather than just creating problems saying that's future Randy's problem, I'll let him deal with it.
Thank you.
Okay, I have no other questions at this time. Does anyone else have other questions?
I do.
You do? Mike Sable.
Okay, briefly, what would your first steps be upon assuming responsibility in this position, and what would you hope to accomplish in this first year? And this is my last questions.
It's your mic. You can have as many as you wish. As far as what my first steps would be, one, making sure we have a contract that memorializes our term, lawyer thing. Two, from a practical standpoint, working with your existing interim attorney, and Mr. Salzman and I are very familiar. I joke sometimes that I'm doing his career a few years later, because he's been in Kenneth City and Indian Rocks Beach too. But we have a very collegial relationship. I would work with him to say, what are the action items what is the work in progress? What are the things that are midterm or near term that have been identified for you? And start establishing the workflow for that. Our firm is fully cloud-based in terms of our operations, and I am a millennial. So I tend to operate digitally, which allows me to at sometimes expedite that transition if those files exist that way, because I can access them anywhere and start indexing them and creating a workflow based on that. In addition to that part of the transition, I would meet with your manager, ask not only what do they need from the legal transition, but get an understanding of where the community is going in your manager transition process. That's going to be a critical part of going forward and making sure if there's an expectation or potential need for legal advice through that process, or just an independent guide. I've served that capacity very diligently, I feel, and I'm very familiar with that. So those would be my two biggest things, given where you are presently. Understanding the workflow, and then ultimately meeting with each of you individually if you're open to it and have the availability, both so we can establish a rapport, and so I can get a better understanding. I mean, I didn't come here sight unseen. I know what some of your platforms were, whether it was, public safety, environmental control, but I want to get an understanding of what is it that you wish to accomplish in your tenure, and see if there's a way to make that a possibility with you and among your peers. That's a really key part of this, right? You came here with goals. You were here in service of something or someone, and I do you no service if I don't know what that something or someone is. So that would be another part of my process in coming in.
Thank you very much. Anyone else? Oh, all right.
To answer the question that hasn't been asked, I am ready as soon as possible for you. I'm not forecasting a 45, 90-day transition. As soon as this community is ready to proceed, I am ready to proceed.
Thank you very much. I think that's all we have for now. Now, do we have, thank you very much, sir.
Thank you.
Thank you.
Someone, Mr. Salzman, is he here?
Yeah.
Hello, Mr. Salzman.
Mayor?
You are with Eunice Salzman Jensen, PA, and you are here to give us a presentation on your firm and what you have to offer Bel Air Beach. So you have roughly 20 minutes, and then we will ask questions.
Thank you, Mayor. Mayor, I want to thank you and the council for the opportunity to assist the city for the last couple months. I've enjoyed, and it's been a pleasure working with Lynn and Patty and the council on moving forward. I think that the council has at least seen from the time that we've been working together some of the things that I'm capable of doing. I have provided a seminar for you all on sunshine law, ethics, and public records. I have drafted some contracts and reviewed some. I've dealt with the employment issues that unfortunately we're dealing with Lynn leaving. I'm familiar with dealing with all those issues. I have been practicing for 36 years in Pinellas County. And so I would tell you that of that time, I started as a prosecutor, as did one of my partners, TR Eunice. Since that time, I have worked in local government for approximately 30 years. Currently represent the city of Gulfport as city attorney, 4 independent fire districts as their general counsel, and a dependent district that is dealing with recreation and library for Pinellas County. My firm is involved in a lot of insurance defense litigation, including that of involving governments. I have worked with Tom Trask over the years on numerous occasions, currently working with him now. So it's somewhat a symbiotic relationship since you do general counsel work and you end up representing some of the insurance defense, you work together. And I enjoy working with Tom and have all the respect in the world for his firm. I believe that I can continue and help the city with what we have started. I think you have some changes that are coming before you. And I think the main issues, at least the way I see them, are the employment matters involving the replacement of Lynn, changes in the zoning, which you have started to deal with, and we're dealing with some additional aspects of that. And also, I think code enforcement is a paramount issue that we're dealing with. I have handled all aspects of code enforcement. I've advised the Clearwater Code Enforcement Board as their attorney for over 25 years. I've prosecuted cases for code enforcement in front of magistrates and in front of the courts. Recently had one for a couple hours in Pinellas County in which we were successful. So all those areas of the law I'm familiar with. There's probably no area that you're going to deal with that I haven't dealt with. I've drafted ordinances, I've drafted referendums, I've drafted contracts. I mean, this no different than really the Trask firm. We all deal with the same issues and we all end up dealing with it. The one thing I would tell you is probably a little different between me and them is that you'll be dealing with me. There's rare occasions when I will not be here. If there's a conflict that I'm on vacation, that's about it. I attend all your meetings. I handle all the matters with the city manager. My firm is available to do additional work, but almost all the time you'll be dealing directly with me. I have the experience doing it, and I believe that I can give the advice necessary to continue on and help the city of Bel Air Beach. And I'm here, Mayor, to answer any questions. I would tell you one thing on my proposal. I tend to charge people hourly. If the city wants to have a retainer agreement, I'm happy to do that. Normally what I do is I use whatever hours that I'm representing you under the retainer. So it's whatever we work out. As you could tell, my hourly rate was $175 an hour. On the retainer that I proposed, it would have come out to about $160 an hour as a discount. But I also like to remind council, there are times when you may not need me that many hours during a given month. So it's up to council whether or not you want to do that. There are months during the summer where you may not be meeting as often, or there might be issues that are going on. And I don't think it's necessary for you to pay me for time I'm not here. So for the most part, hourly works out, but whatever council wants to do is fine with me. Mayor, I'm here to answer any questions.
All right. So we're going to start from the opposite end this time with Mike Zabel.
Okay, same question is, have you dealt with negotiation, mediation, fact finding or arbitration between neighboring communities?
I'm doing one right now for Community Development District in Pasco County. Been handling it for a while. It's dealing with some issues between actually driving and access between one community development and the other. So I'm handling that right now.
I have no questions.
Jody Shirley,
No, I have no questions.
Glenn Gunn,
Not at this time.
not at this time. All right, Frank Bankard.
You were saying about billing us by the hour rather than a retainer. You've been with us a couple months now. How many hours do you feel you've been putting in per month?
We haven't.
I should know this because we get the bills, but
Right. We haven't been putting in a lot of time. I think what we've tried to do is make sure some of the things that Fred had done, well, we can move through, as you're well aware. We're dealing a few things with the zoning ordinance that we just passed, dealing with some things with Lynn and making sure that we had an agreement going forward for him. But for the most part, I thought that maybe we've kind of been waiting until we get this position set and how council wants to move forward. Of course, with a new council, I mean, we had a pretty good workshop in which you all went through a lot of the things and things that we're following up on. So I think council will determine how much time is spent.
thank you.
Taro,
I have no questions.
no questions. Lloyd Roberts.
I know you have been working with us for a couple of months. So, and you've been to our council meetings and also our workshops. Do you think there would be any workload challenges based on the cities and or fire departments you're working with now if you took on this opportunity full time?
No, I do not believe so.
Okay, and I'm going to ask the same question about our sign ordinance. What would be the pathway to correcting the problems we have right now?
Well, based on, and frankly, I'll be honest, Mayor, I could hear some of the comments out there. I think that we would have to do an extensive look at your sign ordinance and make the changes that Randy mentioned to make sure that they're legally permissible. I have drafted amendments to sign ordinances and I've defended sign ordinances, so I'm pretty familiar with the aspects of it. But we would sit down and workshop. We would probably have a proposal for you to look at, and then we would go through some of the questions that council would have. There are, as pointed out, there are some nuances that we have to look at. And ironically, it's a tiny bit similar to what I was mentioning Monday night, what recently came out with the Supreme Court on the flag laws. So we have to be very careful on free speech, and we have to make sure that things are content neutral. That's the first part about it. And the rest of it is then determined based on size and those issues. But it's something that we can put together. I'm not going to tell you to do it in one or two meetings because we want to make sure it's done correctly.
In your opinion, would it be more economically sound and safer to outsource that particular job?
I don't think so.
Okay.
I don't think it's necessary.
All right. Thank you very much. Back to Mike Zabel.
Okay, we'd be assuming this is going to be a fresh start because you're filling in for an existing attorney, but what would your first steps be upon assuming responsibility in the position? And what do you hope to accomplish in the first year?
Well, the first steps obviously are dealing with getting a new city manager, making sure that process runs smoothly for council, making sure we have an employment agreement in place that council is happy with so we can move through that transition relatively quickly. The second part, at least from what I've talked to you all about, is we really have to get a hold of some of the code enforcement that you want handled. There are many different avenues of handling code enforcement. Obviously, you have the sheriff that can come out and handle some of it. Some that we can take to civil court, if you so decide. Some that we can pursue in a quasi, what we call quasi criminal matter, is that's by taking the citations or bringing forth some type of action that would take us into the criminal courts complex. So that's really going to turn on how council feels about that. I think additionally, as Mayor pointed out, that we have the sign issue, and that sounds like one that we need to just jump on. Currently, what we've been doing is somewhat maintaining status quo during this time period. As I said, to make sure that we took care of some of the things that Fred had out there. And at this point, it would be, as you said, starting new and seeing what council wanted us to move forward. My job is to take care of what you need. You're the legislative body, and I'm part of the team that moves it forward. I strongly believe in the team approach. I strongly believe in working with Patty and Lynn, or Lynn's replacement, on bringing things forward to council so that you could deal with it accordingly. So that's an approach that I would meet with them. What I do currently in Gulfport is before the Thursday before our council meetings, I come to the city and we sit down and we go through everything so that we make sure that you have everything that you need for your council meetings and upcoming council meetings, to make sure that we've looked at everything. And if there's something in addition that I need to do, that I'm prepared at your meeting.
Jody Shirley,
I have no questions.
Glenn Gunn.
The city manager very astutely crunched some of these numbers with respect to the billable hours in the last couple of months. So during the interim period, we went back and looked at the billing, and basically it averages about 17 hours a month. And when we went back and looked at Fred Riley's billing towards the tail end there, when we got over some of the issues with who was directing it and unilateral direction for resolutions and ordinances and that sort of thing, it was 17 hours or less. So the only difference is, the way I see it, is the difference in the retainer fees. That's the difference right now, is what I see. And so I guess the question is what do we get for the difference in that retainer fee? Because there is a difference in the retainer fees.
You know, Vice Mayor, and I think I mentioned it, I'm not a big fan of the retainer. And I just put it down there in case you needed it, or some cities like it and some cities like to budget accordingly. If you want to move it down, I'm fine with that. I'm fine not having one. I do not want to be in a position where you're looking at it and saying, well, you know, Andy only billed 12 hours this month and we're paying him a retainer, because then in essence, I'm taking your money. I don't want to do that. I would include any litigation that I'm doing on there, but I prefer to just do it hourly, because you're controlling the situation. And, you know, 1 month, if we're spending a lot of time doing something, you may determine that the next month you don't want to. It's how you set your budget. I mean, of course, obviously I'll be part of attending those meetings when you set your budget, and I'm cognizant of what it is for the city attorney, but I don't need a retainer. I'm happy to bill hourly.
Frank Baker.
That said, your fee is $175 per hour.
Yes, sir.
How long will you lock that fee in for us?
Well, I'm laughing because I actually have a couple clients that have said to me, you really need to raise your rates. You haven't raised them in about a decade.
After you lock it in.
Right. So one of the things I did recently is put in a cost of living increase on an annual basis, which is probably somewhat fair to do. But frankly, if you want me to lock it in for a period of time, I'm happy to do that.
Thank you.
I'm going to make a comment on that. I think this council has decided that we would periodically review all contracts, and that would be the time where we would investigate a rate change. Okay, Leslie Natoro.
No questions.
Lloyd Roberts.
Yes, what are some of the arguments that the city that asked to have a retainer, what is the benefit?
I think it's budgetary, plus some cities feel like they don't want to call you because we're charging you hourly versus, oh, it's in the retainer. It's fine to have them contact them over anything. Frankly, I would tell you, I'd rather you call me or have the city manager call me and deal with an issue that we could discuss on the phone before it becomes a big issue for the city. I have never really had a problem, honestly, in all the years I've been doing this, where anybody's accused me of, or if they thought we overbuild them or spend too much time doing something. So that's kind of why I look at it as it's really a non-issue. I think the 17 hours is probably an average that we'd be looking at if we get involved in some type of action, code action, something along those lines. That particular month might be more. But again, the city's in control of that.
Right. So if we had a $4,000 retainer with your firm, and we only used 15 hours that particular month, we're still out the $4,000.
That's the way retainer works. Now, if you wanted to go with the $3,000 retainer and we reduce the hours, we could do that.
Okay. And if we go over those hours, then it's billable at the $175.
Exactly. So that's why I look at it. I mean, the only discount was it went to $160 an hour
Right.
under those terms. So if we want to do a retainer for a certain amount of hours at $160 an hour, I'm happy to do that.
Okay.
So it's whatever the
Makes
council
sense.
wants to do.
Thank you.
Yes. So if you're unable to make it to one of our meetings, who would be filling in for you?
I have 3 associates that have experience in filling in for meetings for me. I can tell you so far this year, they filled in 3 times. One time was because you all had a workshop that conflicted with one of my meetings for one of the fire districts, and the fire district didn't really need me at that meeting. So it's very rare. I have the second Monday of the month I have a fire district meeting at Palm Harbor. So that was the one conflict, but I will tell you, I'm planning on taking a vacation in June. I think it's 10 days, so it would probably cover 1 meeting.
We don't allow vacations.
Well, and I won't be taking a vacation in June. You'll have to deal with my wife.
Make it on your retainer time.
Thank you very much. Back to Mike Zabel.
Yes, are you board certified by the Florida Bar on city, county, and local government law? And if not, what does that really bring to the table?
Well, I'm not. My partner is in civil litigation. I would tell you that, individuals study hard for that and they actually obtain that. I know that Tom and Randy have that, and it's an impressive thing to do. Really hasn't been any interest for me to do. I've been representing my clients for a long period of time. Really don't bring on too many new municipalities or government agencies, so it hasn't been an issue for me.
Jody Shirley.
Yeah, I'm good. I don't have any questions.
All right. Glenn Gunn.
I raised the question about retainers and the differences in that, and you've responded, and I may have moved the goalpost here a little bit, and I'm just wondering if Mr. Mora has any further inputs, because I don't think we addressed those questions with retainers to him, and I don't know if it's appropriate or not, or just leave it at that.
I think the way that I would like to handle this is after each firm does their presentation and they've answered our questions, then we'll call on, everyone will have the opportunity to go back to each team and decide. So back to Frank Baker. No more questions? Leslie Nataro?
Nothing.
All right, Lloyd Roberts?
Nothing additional? No.
All right, I have no more at this time either. Thank you very much. Okay, so let's go to council, and does anyone have any questions for either team at this time? No. Glenn Gunn.
Yeah, I'll just call him Mr. Mora. I mean, I raised the issue about retainers, and I don't know if you have any inputs or insights to what we should think about when.
Several, and I appreciate the opportunity to address that directly. First, I want to explain, we proposed a retainer. If you'd prefer to go hourly, we're happy to do that. We proposed what we thought, based on having reviewed your historical billing and otherwise what we thought would be advantageous for you. One of the reasons we propose a retainer in this particular community, as Attorney Salzman aptly noted, in our experience, there are some communities where the cost of using the attorney creates a chilling effect on using the attorney. We recently entered another community where we went by the historical billing, crafted a retainer, and then once we came in, found the legal needs were actually exponentially higher once we brought our proactive approach in. And people said, oh, I didn't know you couldn't do that, or, oh, we haven't looked at this policy in a long time. And I still maintain that I think that was the right decision for them and the right fit for them, maybe not for us financially in the short term, but it's helped them to get where they need to go. I say that again to reiterate, if this community is interested in working with us and would prefer an hourly arrangement, we're happy to do that. I will also tell you that while we enter into multi-year contracts, depending on what a community wants, we revisit those agreements. I mentioned that I'm the town attorney for the town of Kansas City. We entered that community in 2012 because an attorney promptly and somewhat unexpectedly resigned, and we came in as interim services, just as Mr. Salzman has here. And at the time, we had a $4,000, and then ultimately we became their town attorney, and we had a $4,000 retainer because they had a lot of needs. Over time, they changed their form of government. We noticed that the needs of legal services dropped, so too did their retainer. We adjusted it in light of that, and we regularly evaluate is our financial arrangement equitable for both parties, both us as a firm and you as a community. I would also add, that as we look at the financial arrangement, the way our retainer is structured, Mr. Roberts, to answer a question you asked Mr. Salzman, there may be a month where you don't get to that full value, and there may be a month where you go over. The number is the same. There's not a, once you reach X amount of hours in our proposal, now you're paying over and above the retainer. So if you have a month where you bill, we only give you 15 hours of service within the retainer, and then the next month for reasons unexpected, you balloon to 40 hours, it's that same number. Unless we're doing litigation or a special project, something very clearly outside of it, we keep that, and that creates challenges and opportunities for us, but we create that number understanding it's sort of the law of averages and trying to reconcile that for a community. But I would tell you that we are most interested in serving you. And with that in mind, we are happy to, if you're looking for something more flexible in the financial arrangement, happy to discuss that and revisit that. However, we proposed a retainer based on your needs. And while past performance may be an indicator of future behavior, we have found in many instances, it rarely is, because our approach is different, because we tend to be a bit more proactive. It can create more work, not make work, not work for the sake of billing and churning, but trying to get you ahead at a faster rate rather than just rolling with each punch as it comes in.
Thank you.
Great. I have a question for the city manager. By any chance, would you happen to have the average expenditures, what we've spent on city attorneys for the past 3 years?
Excuse me, I don't have the last three years with me, but in most cases, I can tell you that it was over 3,000 and got up to 5,000 the last couple of years.
Okay, so it's safe to say it was easily more than $36,000 in a year.
Yeah, oh, yes, over the
Okay.
last few years.
Now, given a normal term, it would normally be much lower. Is that correct?
I'm just going to give you the average. It would probably be somewhere between, I'll say, 2,500 and 3,500. So, but over the last couple of years, it's been much higher because of the situation.
I understand. All right, thank you. Counsel.
Yes, I have a question, Mr. Moore. Specifically, we've had, let's see, 2 regular meetings. We got this meeting this month. We have the traditional council meeting. We'll have a work session. If you cannot make a meeting, will an associate or a full partner be able to make our meetings?
It's a great question. First and foremost, I want to tell you that I make every effort to be at every meeting. In Kansas City last year, I had more than 23 meetings last year. I did not miss one. I will take a vacation, or you can also deal with my wife at some point. But where we try to deploy who's the best fit for your community and for the issues you're discussing. I missed my first Kansas City meeting last week for the first time in several months because they scheduled a workshop on the fly, and I did not foresee that coming and had a commitment out of the area. I sent an associate, but he's our senior associate. He's Robert Eschenfelder. He's been a city attorney. He's been working as a municipal attorney for over 30 years, and he had specialization in procurement, and they were doing a solid waste procurement contract. So no, I didn't send a full partner, but I sent the person with the most knowledge who is best positioned to provide them legal advice in the moment. So I wouldn't say that I make my decision based on whether somebody has an investment holding in our business. I make it based on what is the best need for the community at the time. And it might vary also by, is it an advisory board on a preliminary basis? This is the first tier. We don't need to bring that heavy cost to bear that way.
So there would be a question that you could work with the city manager to find out who is probably best knowledgeable about that one topic that would be encountering for that meeting.
Correct. And I will tell you that as a general matter of practice, I speak to my managers almost every day. Greg Mims down the street and I talk almost every morning on my commute, or at least twice a week on my commute. What's going on? What do you need? What's in the hopper? Whether it's Mr. Reeves or his successor, whomever he or she may be, I would be in regular contact, have a firm assessment. And even though we may have worked on Thursday before the Monday meeting, I will call Monday morning and again at 3 o'clock to say, hey, anything come up over the weekend? Anything come up over the business day? Any unexpected surprises we should prepare for? I want to make sure I'm prepared to work with you, and especially if I'm having somebody covering. My colleague Jeremy Simon covered an advisory board meeting for me, and he and I met for an hour to make sure he was fully versed not only in what was expected, but all the things that could happen.
Okay, Mr. Salzman, same question to you.
Can you repeat the question?
Sure, absolutely. In your absence, you talked about having an associate cover for you. Is there an availability where we could probably get more of a subject matter expert if there's enough time or lead time to support you or represent you when you're not here?
Absolutely. It would be no sense for me to send an associate that couldn't help you. You might as well just not have anybody in the chair. We would have them make sure that they're updated on any particular issues that are coming forward. Lynn and I, or Lynn's successor, as Randy said, we will be dealing with them to know what's going on. Lynn and I talk throughout the week, basically to make sure that we're handling whatever needs to be handled or what's upcoming, so that we can make sure that we serve the council correctly. So absolutely, I would have somebody here with whatever issues there are and updated for whatever matters may come before you.
I have a question for both of you. Mr. Salzman, you can stay up for now and answer first. If one of us decided to start abusing the privilege of communicating with you directly, and it appeared to be a conflict, how would you handle that?
I would talk to the city manager and I would set up a meeting between that particular council person, the city manager, and myself. Unless the issue was dealing with the city manager, then I wouldn't do that. One-on-one conversations. I've had those conversations with commissioners over the years. Normally see it with somebody who might be new and wants to get involved in the day-to-day operations. Really can't have that. Have to talk to those commissioners individually. One thing that I will tell you is that I try to avoid at any point embarrassing a council member at a public meeting. I'd rather deal with the issues privately and make sure that they understand what the ramifications can be. Over the years, and I'm sure Randy can probably say the same thing, no matter what you say, somebody's going to do something anyway. You deal with it after the fact, but we try to avoid making sure that the person isn't embarrassed, that we have the answer to the question that they need beforehand, and that we deal with any of those issues.
Thank you very much.
Thank you again for the opportunity to respond. It's a very valid question. And sometimes it's somebody who's new and wants to get involved. Sometimes it's somebody who has a lot of time. I had a council member once who suddenly took a much keener interest once they retired and how much we started talking. I will tell you that your RFP seeks somebody who can maintain positive working relationships with internal and external stakeholders with the ability to be politically savvy. It may sound like a bit of a joke, but my fraternity nickname was Colin Powell. That was not a drinking story. That was just who I was. I'm somewhat known for being as diplomatic as possible. I may use words with a few too many syllables from time to time, but my first step in addressing the issue you proposed would be to have that conversation with that individual directly. To say to them, listen, let's talk about what your charter says, your code says, what your internal policies say. Remind them, hey, I was at a meeting where I interviewed for this job and I pledged to you and your peers, if it's one of you or somebody new to your peers, that I work for the group of them and not for one person. And if this is really something you're passionate about, let's see if we can make that happen by getting the buy-in of your peers. If it rises to the level that it's a problem and that no matter, as Mr. Salzman said, no matter what advice or counsel you give them, that they're not interested in that, I would perhaps raise it with your manager, but ultimately, it may ultimately be something I raise with you folks and say, the services are being used this way. It was contemplated that it would work in a particular fashion. We're deviating from that. If there's been a change in your policies as a council, please let me know. And so we can adapt accordingly. But if not, there is a certain element, and it's not spoken of often, and it's somewhat unpleasant to address, but there's a certain element of being on a council, being part of a group that requires self-policing. And in some communities, you may be in the minority voice and say, I don't like where this is going. I don't want this to happen. But wherever 4 or more of you go, that's where we're going. And I can't change that. You're all adults. You're all grown folks, and you can make your own decisions on how you choose to comport yourself in this world. And if one of you goes in a certain way and 3 others say, I don't really see an issue with that, Randy, grow some thick skin, then that's what's going to happen. And I can't change that unilaterally. So I will tell you that I will work with all of my colleagues to make sure you're successful. And if there's one person who's doing something that's different than that, I will first address it with them. I believe in direct conversations before elevating things. And if they need elevation, again, just as Mr. Salzman said, as diplomatically as possible. I have no interest in being in the public eye that way at all.
Thank you. Anyone else? No? Okay. Is it time to go to a vote, or would you like to have a conversation? No? Everybody good? Okay, well, I think it's time to vote then. So we have a ballot here, and there's 2 names on it. I need everyone to pick one and make sure that you sign your name, and then we'll take a count.
I would like to say just quickly that for us, this is a win-win situation from my perspective. I mean, we have 2 great options. I don't consider either one of the options to be a loser in this scenario. It's just somebody who didn't win. So again, I want to thank everybody for participating tonight, and may the best team win.
Nicely said. Okay, before we get the ballot count, I'd like to thank both firms for coming out and applying. You're both great candidates, and as Mr. Roberts said, we would be truly blessed to have either one of you. I think now we're going to take the roll, and we'll find out exactly how this this ends up. Patty, may we please have the results?
Councilmember Bankard voted for Mr. Salzman. Councilmember Notaro voted for Mr. Salzman. Councilmember Roberts voted for Mr. Salzman. Councilmember Shirley voted for Mr. Mora. Councilmember Zabel voted for Mr. Mora. Vice Mayor Gunn voted for Mr. Mora. Mayor Gaddis voted for Mr. Mora.
Okay, so that's 4-3, and the position is awarded to Trask Daniel LLP. Congratulations and welcome aboard. Okay, if we,
Thank you, council.
oh, thank you so much. Thank you. Okay, we have no other items on this agenda. Do I have a motion to adjourn?
Motion to adjourn.
Frank Bankard, do
Second.
we have a second? Leslie Nataro, all in favor?
Aye.
We are adjourned. Thank you.